All right, so before our face-off at 9 p.m., the big questions that we pose: jail or not bail, the principle for a draconian law like UAPA. Prolonged trial means prolonged jail. Well, that is what an understanding came off the reading of the order today by the top court of the country and the bench. The other question that we pose: UAPA prone to misuse by the state, criminal justice system flawed. Let's take all these questions to our panelists this evening. Joining me, Satyapal Jain, Additional Solicitor General of India, Colin Gonsalves, Senior Advocate. I'd like to begin with Mr. Satyapal Jain. Mr. Satyapal Jain, how do you, somewhere down the line, reconcile the principle of Article 21 that stands for freedom and liberty with what the court said today? And to quote the order, over 5 years without incarceration, prolonged pretrial detention should not equate to punishment. How do you reconcile both, especially at a time where trials move at glacial pace, delayed systematically, where charges haven't been framed yet? How do you reconcile that?
To my mind, it's a very balanced judgment. It has taken into consideration all the facts and evidence of the case on file, as well as the law which is prevalent at the moment. You see, understand the principle of criminal law. Any person who is arrested by any agency, prosecuting agency, the moment he is produced before the court, then it is for the courts to decide whether to grant him bail or not to grant him bail. Any accused
I'm sorry to interrupt, and
special...
I'll allow you to continue, because at least with what we've learned, and you're way more learned than most of us, because we have not a deeper understanding of the law, the principle and the tenet of criminal justice lies on the fact of presumption of innocence. Innocent until proven guilty.
I'm replying to your question. Basically, now this issue, whether he is entitled for bail or not, is not decided by the government, not decided by the prosecuting agency. After the arrest, within 24 hours, the accused is in the custody of the courts. So if you have to apply for bail, maybe a normal law, maybe a special law, maybe UPPA, maybe PMLA, whatever it is. In the present case, both these people, all the people applied for bail. The trial court dismissed their bail application. High Court also dismissed their bail application. And today the Supreme Court, out of 7, has granted bail to 5 and has declined bail only to 2. Why are we forgetting that the same bench, which according to some people did not apply the principle of no bail, no jail, etc., they have already granted bail to 5. And when they have granted bail to 5, declined bail to these 2 persons, the judgment, which is 142 pages judgment, has dealt with the whole issue in detail. The court has found that these are the persons who are indicate a central and directive role.
Mr. Jain, allow me to come in again. Allow me to come in again, because you talk of granting bail to 5 and not granting bail to 2.
Yes.
But the fact is, sir, that today one might say, and the court said, that these two are of different footing and their nature of participation in the crime was different. But for the last 5 years, they were pulled in with the 7, where they were denied bail together. They were put together as a part of a larger criminal conspiracy. And suddenly you define their role differently this time.
Madam, please, I will not like to comment on your comments as a lawyer, otherwise I can say many things. See, when the charge sheet is filed, there are hundreds accused in certain cases, 50, 20, 10. Now the role of each and every is different. Ultimately, it is the court which examines what is the role of each and every person. For example, you murder a man, somebody fired at it, another helped him, another got something. The role of each and every person in any criminal case is different. And ultimately, when the screening takes place, it is the highest court of the country which has examined the entire evidence and has come to the conclusion that other 5 may be given the benefit of bail.
With what you say, the hierarchy of participation, something which the court also used, you don't find it in conflict with Article 14, equality before law?
Article 21 doesn't mean that
Article 14, which is violation of Article 14, sir, equality before law.
That principle, if Article 21 is applied in that way, then everybody will be released on bail, whatever the offense. No, Article 21 is subject to the regulation by the laws of the land.
UAPA, so I'm talking about Article 14, like I said, you're way more learned. I'm talking about Article 14, equality before law.
Article 14 is
with
not
what you
available
call the hierarchy of participation.
Article 14 is not available in criminal law. It's a civil matter in the matter of services and all that. Criminal law doesn't recognize Article 14. Your role can be different. 2 persons committing offense, one may be the major role, another may be the side role. The court decide accordingly. Let's be very clear about it.
All right, so I want to bring in
of Article 14. So far as the delay party is concerned, Supreme Court has found that delay is not attributable only to the prosecuting agency. Delay is attributable to them also. They have also been getting dates after dates. So it's not that delay is
No,
only
fair
because of
point. But Mr. Satyapal Jain, the fact is that the key witnesses haven't even been questioned yet, that charges haven't been fixed yet. Do you not think that this is a blot on the judiciary, which we'll come back to? Allow me to bring in Colin Gonsalves, Senior Advocate, Supreme Court. Mr. Gonsalves, the court also said, and so did the prosecution, reiterate the fact that a large part of how slow things have processed is because the accused constantly kept cancelling dates, and the onus lies on the accused why the trial is so slow. Sir, you're on mute. You're still on mute, sir.
No, not true at all. And let's not take that, let's not allow such an excuse to come on air again and again. The conduct of a trial lies in the hands of the judge. It lies in the hands of the public prosecutor. The accused here did not delay the trial, but even an accused who delays the trial can be treated very tough by the court and the public prosecutor, and not a single day's delay can be allowed. You have control of the trial. Therefore, do your trial. And look at the travesty of justice here. 800 witnesses, 5 years pass, not one witness examined. Is it not deliberate inaction on behalf of the state? Passing time, wasting time, to see that ultimately, he will stay 10 years in jail and still his trial will be at some initial level. It reminds me of the emergency. Madam, it reminds me of the emergency. And it reminds me of the terror of the emergency, Indira Gandhi's emergency, where people were locked up and, lost sight of. It reminds me of the emergency because no one had the courage. No court in the country had the courage to stand up to Indira Gandhi. God knows why, but they could not stand. These are shades of an emergency. And the people who are in jail today are like all those who were in jail in Indira Gandhi's time. They suffered in jail. Many of them in the opposition in government today. They suffered in jail. And when they came out, they were treated as if they were heroes by the Indian public. I know Khalid. I know these people. I've seen their work. Never thrown a bomb, never done violent actions, never fired a gun, never, ever a single act of violence not alleged against them in the charge sheet. No violence alleged. Some speech that he gave. And he started the riots. I handled today the Delhi riots case in the High Court. The case that I filed is for an FIR to be registered against those who started the Delhi riots. And you know who did it? Anurag Thakur, Parvesh Verma, Kapil Mishra, who stood on a stage and said, and I gave the videos to the court, Desh ke gaddaro ko goli maro salu ko. And after giving those very insightful slogans, walk through the streets of Delhi repeating the slogan. That is how the Delhi riots began. I've got it on video. I filed it in the court. Supreme Court directed the High Court to expedite this matter 3 times. 5 years have passed. The High Court has not even begun the matter. Reluctance to start a matter because their own leaders will be found out to be the persons who started the riot.
Mr. Gonsalves, the question I'd like to ask you is, do you fault the draconian archaic law like the UAPA, or do you think the reading of the law was flawed in this judgment today, which denied bail to both Umar and Sharjeel?
See, the law is archaic, not archaic. The law is draconian, but I don't want to make that point. I don't want to make that point. The implementation of the law by the government and the courts, particularly in this case, passing such an awful order against judgment after judgment of the Supreme Court in UAPA matters. 3 years, your trial has not begun, bail. 4 years, your trial has not begun, bail. The historic judgment of the present Chief Justice of India, historic judgment in Najib's case, all UAPA cases. 4 years have passed, and there's no chance that your trial will finish in the near future, bail. 10 judgments of the Supreme Court, Vernon's case, other cases, 10 judgments
Okay.
at least.
I want to bring
And
in.
now you have a judge, or now
Stay
you
with
have
us.
a bench.
Mr. Gonzalez, stay with us. I want to bring in Satyapal Jain back into this conversation because Satyapal Jain, it's been 5 years. 5 years where, charges haven't been framed, bail hasn't been given, key witnesses haven't, been examined where the Delhi police is concerned. Now, on that account, because of the various judgments and precedents that Mr. Colin Gonzalez gave, I'll give you two. You have the bench of justices Abhay S. Okha and Augustine George Massey, who clearly stated and ruled, bail is rule, jail is an exception even if it involves a UAPA case. Then you have I.B. Pardiwala and Ujjwal Bhuyan observed that the right to bail of an accused cannot be withheld as a punishment irrespective of the nature of the crime, even if it is under UAPA, sir.
Madam, please understand the working of the law, criminal law, the principles of the criminal law. As I said earlier also, there is no question of any Article 14 or similarity in criminal law. Each case has to be decided on the facts and merits of each and every case. You cannot apply any hard formula to each and every bail application. The Supreme Court is the final authority as per the powers given by the Constitution of India. The two judgments that you are citing, they are also by the Supreme Court. You can't expect that every judgment will be as I want it to be. You don't want that the way you want the judgment should come. If it is not that way, then I say, no, law is not being followed, it is being flawed. The Supreme Court, I have got this 142 judgment with me, which has given all the reasons of giving bail to 5 and also reason of not giving to only 2 people. And Supreme Court has given them 1 year, that in case the trial doesn't take substantial
What will happen in that 1 year,
during
sir?
this period.
What will happen in that 1 year that hasn't happened in the last 5 years?
I'm telling you, within 1 year, if the prosecution doesn't proceed with the trial, material witness, the court has said, you can move for bail after the protected witnesses have been examined. Because if the accused come out, sometimes there are many cases where they threaten those witnesses also. Therefore, the people are kept in jail in certain cases so that they cannot influence the witnesses.
The court has,
so
Mr. Jain, the court has said that
court,
until the witnesses have been examined or 1 year, whichever comes in first. By the speed of the investigation, it doesn't seem that the witnesses will be cross-examined. And I'm just I am just taking the example of what has happened in the last 5 years, sir. So what will change in the next 1 year, or will suddenly Article 21 kick in, which doesn't kick in right now?
The Supreme Court has laid down the time limit that if within 1 year, no substantial progress takes place, they can apply again for bail. Supreme Court will examine that. Let's have faith in Supreme Court. We can't dictate Supreme Court that you decide in this way, because in that case you have said so, you say same thing in this case also. Supreme Court has to examine the merits of each and every case. Let's not forget Arvind Kejriwal was also granted bail. A few days back, some man was granted bail by Delhi High Court. Supreme Court stayed that. Unfortunately, when the judgment is as we are expecting it to be, we say it's very fair. And sometimes when it is not as we are expecting, so we come on many people, emergency and all that. That is not the law. We have faith. We should have faith in the Supreme Court.
Okay, sir, like I said, I am no lawyer, I am a journalist, but at least one thing I have learned, and you can correct me if I'm wrong, the sheer foundation of criminal justice is the presumption of innocence. And that is the tenets which criminal justice stands on, which is the presumption of innocence, sir.
Yes, but that doesn't mean that every person who is accused of any crime will be released on bail. If you apply that principle, lakhs of people who are in jail, murder case, rape case and all those cases, everybody will be released on bail. No, the court will examine whether there is a prima facie case against you. If there is a prima facie case, as the Supreme Court says,
5 years without trial, 5 years without trial, without framing of charges,
Supreme
you know,
Court
to
says
defend that,
the-
I would think is a blot on judiciary, but then I'm just a journalist.
that's a
I
different
am
thing.
no
That's a
lawyer. I
different
would
thing.
want to bring in Mr. Gonzalez into this conversation. Mr. Gonzalez, this is the UAPA. This concerns anti-terror activities. It concerns sedition. These are very, very strong laws. Might be draconian, but it is the reading of the law. You're on mute again, sir.
Law has been read many times in many judgments of the Supreme Court, even in 2025, 2024, recently. So many persons have been released with 3 years in jail. So many. And the principle has been reiterated 100 times. If you can't do a speedy trial, which is in the hands of the state, you cannot keep a person in jail. And what has the court done? It has kept our finest human rights activists. I must tell you, the two who have been denied bail are one of the finest human rights activists of India, who used no violence, who only criticized the government in the strongest possible way. They are in jail for no crime except
Supreme
free
Court has,
speech.
Mr. I'm
And
really
that is
surprised.
the
Have you read the
emergency
judgment?
of
Supreme Court
Indira
has mentioned
Gandhi
their role.
all
Please,
over
you are
again.
such a senior lawyer.
This is the
Kindly read the
beginning
judgment. Supreme
of
Court
the
has
emergency of
detailed
Indira
Let's
their
go
Gandhi
one by
role
one,
in
sir.
the judgment.
all
It's
over
very
again.
Okay, I appreciate
very
it.
To
Okay,
stand up
I'm going to end it here. I appreciate both of you for joining us. For now, both Sharjeel and Umar Khalid have been denied bail. They've been given 1 year to reapply until the witnesses are cross-examined, or it's a year, whichever comes in first. We're going to leave it at that.